This meeting come to order. Today is Tuesday, July 12, 2016. This is a study session for the Prescott City Council. Today we're going to be looking at probably the first effort at coming up with ordinance language to try and implement Noel Campbell's House Bill 2107, which covered structured sober living homes. Since this is a very first look at the ordinance, I'm not going to have any public comment today. I know this will come up probably 3 or 4 more times before it ever comes to vote, and I will ask for public comment even during future study sessions on this. But I think today, since we're just barely starting to scratch the surface, I will not take any public comments. So we're ready to go to roll call.
Mayor Oberg?
Here.
Mayor Pro Tem Lamerson?
Here.
Councilman Blair?
Yes.
Councilman Lazell?
Here.
Councilwoman Orr? Here. Councilman Shiska?
Here.
And Councilwoman Wilcox?
Here.
All present.
First item, please.
Item A, discussion regarding possible regulations for structured sober living homes.
Mayor and Council, I'm going to do it from here standing up so I can see the slides better. Today we're going to talk about, again, sort of an outline of what Noel Campbell's bill is going to be once it takes effect is ARS 9-500.38, which it takes effect August 6, I believe. So we're going to talk about the ordinance today and some possible options for the council as far as what could go in the ordinance, and then hopefully maybe get some direction to bring back some drafts of different options for the ordinance. So the purpose, let's talk about the purpose first, so just very clear to the council and the public what the purpose of this type of ordinance would be. And that first of all, we have to carefully craft this ordinance because there are a lot of implications, and I'll get into a little bit in a minute, for Fair Housing Act, ADA, equal opportunity type employment. But the primary purpose of this ordinance is going to be to protect the residents of structured sober living homes. That's the primary purpose. By way of background, we have a very aggressive, I think, land development code, zoning code dealing with community residences. It's survived 2 HUD challenges. The HUD investigators said it's cutting edge. It could be a model for cities that have similar clustering problems as Prescott does with group homes or sober living homes. But it meets the intent of the Fair Housing Act, our current zoning ordinance. So we are sort of at the forefront of that issue, I think, in Prescott here with our zoning ordinance, dealing with primarily the clustering issue with community residences or group homes. So that's of course a challenge because we have to make sure we meet ADA and Fair Housing Act requirements. We also have, and we've talked about this a number of times, a number of other ordinances dealing with disruptive properties, nuisance, and property maintenance, building safety. As you know, I think you know, last Friday a letter went out to all of the known community residences informing those operators that we're going to be start doing our building safety inspections, ingress, egress, making sure that they're meeting the building code capacity requirements in terms of the number of people going to live there. So Prescott, we've done a lot so far to deal with the impacts, if you will, of community residences in Prescott. This ordinance, if it takes effect, sort of fills a gap, and that gap is the protection of the residents themselves. And by protecting the residents from operators who don't provide support, oversight, a residential family-like environment, once we have that protection for residents, the secondary benefit of that is going to protect the neighborhood and the neighboring community around those. Because if you have a well-supervised home, the theory under this bill, the statute, is that will benefit the neighbors around the home. If the home's well-supervised, if the residents are well-supervised, well taken care of, then there's less likely chance for disruption to the neighboring community. And of course, the end state, the end goal for this purpose, as well as the homes themselves, is to achieve and maintain sobriety. And so, talked a little bit about the past. There have been studies that have said a well-run, well-managed, positive living environment actually helps achieve and maintain sobriety better than poorly run, mismanaged homes. That a resident is more likely to leave to not successfully complete a program if a home isn't well run. So there is a positive goal here.
I got one question real quick.
Sure.
We talk about residential family-like environment, so we're talking basically about homes in neighborhoods?
We are, Mayor.
We're not talking about commercial establishments?
No, we are talking about structured sober living homes, which are basically single-family residences of in our situation, 5 to 12 unrelated residents who are all suffering from a disability, and that disability would be alcoholism or drug addiction, and they're all in recovery. So that's the goal here. If it's an institutional-like environment, like a dormitory kind of situation, more than likely that falls out of a residential use. It's more of a commercial use, and there's probably more likely a state licensing scheme that would apply. Mm-hmm. And as we'll get into this, we're talking about homes that aren't licensed or regulated by Department of Health Services. We're talking about unlicensed, essentially unregulated operations of the residential side of it.
Okay, Councilman Blair.
One quick question, if I may, Councilor, will you clarify to not only us here in front, but also the residents, how many people that are related can live in a house and how many people that are unrelated can live in a house at this current time in our code?
Under our current city code, the number of related people by blood, marriage, and there's one other term, but basically related people it's an unlimited number. Provided, however, that it meets the building code, the building safety code. In other words, if it presents a health hazard, whether it's there's an ingress-egress problem, whether those kinds of things, that would trigger that sort of objective building code. So the number of related people is pretty much unlimited under the zoning code. The number of unrelated people that can live together is 4 as a matter of right. In other words, 4 unrelated people are deemed a family. Whether they have a disability or not, they're considered a family and can live in single-family residential as a matter of right. If it's 5 to 12, and they're 5 to 12 persons with disabilities, it falls into one of 2 group homes or community residences, or our traditional sort of community residence or group home, and our transitional. Traditional is a community residence that the length of time that a person or a resident would live in the home is measured in terms of years, or it's sort of indefinite. So if you're talking about a group home or community residence, and I'm going to use those 2 terms interchangeably, group homes is just easier to say, that would be for like developmentally disabled. There's the time frame within which a person resides at a group home is kind of unlimited. It's measured in terms of years, and that more emulates a traditional or typical family type living arrangement. And that type of group home, the 5 to 12, would be allowed as a matter of right in single family residential. If it's transitional group home, that length of time for the residents is measured in terms of months, 6 months, 9 months, maybe up to a year. And that's more reflective of our structured sober living homes. Those are allowed in multifamily zones as a matter of right. There is a way, by way of a reasonable accommodation process or a use permit process, to have that use in a single family residential area, but there are some conditions that would apply. And the reason that a transitional community residence is allowed as a matter of right in multifamily is because it more emulates a multifamily type living arrangement, where it's usually a year at a time. You release an apartment for a year, and then you might move out. You may sign a new lease and live in the same apartment. But multifamily apartment type living is more measured in terms of 6 months, 8 months, a year time frame. So that's how we sort of distinguish between the two, I guess, types of community residence we have: the traditional group home and the transitional group home.
Okay, so a transitional home in an RA 18, RA 9, RA 36 residential neighborhood is precluded in the code?
In a single, currently, in our land development code, it is prohibited. It is not a use as a matter of right. Now, again, you can, if there's a reasonable accommodation that's necessary, or by way of a use permit, it can be allowed in single-family residential. But there's a process that an applicant would have to go through in order to obtain that ability to place a transitional community residence in single family.
But they're under city code violation if they come into, let's say, Eagle Ridge moves next door to Mr. Shiska and put in 8 people. That's a violation of the city code.
If it is a transitional community residence, yes.
Thank you.
If it is a traditional, a group home for the development disabled, no. But by the way, that 5 to 12 number is also then tempered by the building code that says effectively you can have 2 people per bedroom. I mean, there's some nuances there, but it's essentially 2 people per bedroom, plus your resident manager. So generally speaking, a 3-bedroom house would allow for 6 residents, and then a house manager. Okay. Now, again, depending on size of the bedrooms and some other exceptions, the number can go a little higher now. But that's our building. Our building code imposes that.
But I think those 2 definitions are important for our community to understand what they are.
Right.
Thank you.
Now, just to sort of clarify too, we clearly have transitional community residences or group homes in single family. Once the ordinance was adopted, those were considered grandfathered or legal non-conforming uses. So they all were allowed to remain in those single family neighborhoods or single family zoning areas unless they ceased operations for at least 6 months, and then that use would have been abandoned. Okay. All right. So we know what the purpose of all this is, and here's the intent. The intent of this is to protect the residents of the structured sober living homes from operators that engage in abuse, neglect, mistreatment, fraud, inadequate supervision of what is deemed a vulnerable population, essentially a disabled group. A couple of limitations we're going to always have to deal with in this issue is Fair Housing Act, ADA, and in this particular ordinance, equal opportunity employment issues or statutes. So what's our intent? We have to achieve a legitimate government interest. We have to intend to achieve that a legitimate government interest. We have to actually achieve that interest with what we ultimately adopt, and we have to use the least drastic means necessary to achieve that interest. So we can't be draconian. We have to use the least drastic. In other words, if we can achieve one of our goals, we have to do it in the least sort of oppressive way or drastic way. That's what the Fair Housing Act and ADA and EO statutes require.
John, excuse me.
Oh, okay.
Excuse me, Mayor. Would these be considered transitional homes? Would they be considered businesses?
No, they're considered residences. They're considered residences in terms of the residents who reside in the home. That's their home. So for Fair Housing Act purposes, that's their home. However, the operation of the home is considered a business. So kind of a distinction without a difference, but the conclusion we've made is, as far as the business licensing goes, is the operators have to get a business license, whether it's for each of the homes or if it's for their operation of the homes that lists the various locations. So by way of the business license, we should know, by enforcement of the business license that goes into effect on January 1, the location of our community residences.
Thank you.
To the extent we don't know those now. Okay. So let's get into a little bit of the meat of what the statute, what the bill, I'm going to refer to as a statute because we're close enough to the effective date. So under the statute we're talking about, what is a structured sober living home? And it's up there. It provides an alcohol or drug-free housing, promotes independent living and life skill development, provides structured activities that are directed primarily toward recovery from substance abuse. That's the key words in this. It has to be a supervised setting. So in other words, if it's simply a group of recovering addicts or alcoholics who choose to live together on their own as roommates, that use would not fall within this. That's simply 5 people, 4 people choosing to live together on their own. This is part of the structure is a key term here. Obviously, they're unrelated individuals. They're recovering from drug or alcohol addiction, and they're receiving some form of outpatient behavioral health services. So generally speaking, the community residences that we're dealing with are all tied to, in one way or another, an outpatient service, an outpatient behavioral health service, whether it's, AA or some other form of outpatient treatment.
One question, we talk about alcohol and drug-free or drugs. I think there's maybe one or two homes in town that are for gambling addiction. Should that be included here?
Well, not under the statute. I mean, the statute strictly deals with the drug and alcohol recovery. So if it's a truly a structured recovery home for gambling addiction, arguably it does fall within the community residence definition. But, Mayor, off the top of my head, I don't know if gambling addiction has been deemed a disability or not. I just, it's one of those things where I could look it up, but I don't know the answer off the top of my head. If it's considered a disability under law, then those folks would have the same protections as people in alcohol and drug recovery.
What about sex addiction?
Same answer.
Same thing.
Don't know the answer. And I'm not, let me make it clear, I'm not saying that it's not an addiction. I don't know if as a matter of law it's deemed a disability or not. So, now what the definition doesn't include, as I said, is a private residence. Just to be clear, a structured sober living home doesn't include a private residence where a family member, a related family member, is somehow required to receive outpatient behavioral health services for substance abuse or addiction as a condition of living in that residence. In other words, if parents tell their child, you can continue to live in our home, but as a condition of, an adult child, as a condition of living here, you have to go through some treatment program. That's not considered structured sober living. So if it's a family sort of confronting the addict and making it a condition of residence at the family home, that's not included here. That's simply sort of family private business, I guess. Okay, so what does the statute authorize? It authorizes the city to adopt an ordinance that sets out standards for structured sober living homes that must comply, and this is the language of the statute, with federal fair housing laws and Americans with Disabilities Act. I would also suggest that it's the state and federal fair housing laws. They tend to mirror each other, so that's always going to be our sort of governor on this, is what we're allowed to do in this ordinance is always going to have to be measured against, are we in compliance with Fair Housing Act and ADA? Okay, so what are some of the specifics that the statute allows us to require from an operator? We can require basically a registration of that home. Name and address of the home, information about the property, such as the property owner's name, address, contact telephone number. If the property is leased by the operator, then we can require a copy of the lease. And we can require that the lease clearly states that the home is going to be used for a structured sober living home. As you know, we've had situations in the past where a landlord will rent to an operator, and the operator will say, this is going to be my primary residence. And then the landlord, maybe an out-of-state owner, finds out 6 months in, my house is a group home. And I thought that this guy was just renting a house from me. So we can require that there's disclosure, essentially, to a landlord that the home is going to be used for this type of use, and then the landlord can make that business decision whether or not he or she wants to rent to that user versus a traditional family or something else, or college students. We can also require that the operator develop some supervision requirements for the residents of the home. And then we can also require that the landlord, or that the operator develop an operations plan that helps facilitate the rehabilitative process, including discharge planning, and addresses the maintenance of the property as well as noise abatement consistent with our local ordinances. So what that means is there's been a problem, whether it's anecdotal or data, of what the term in the industry is streeting. Somebody violates the rule and they're kicked out on the street, and they've got no other options for where they may reside that particular day or there. So we can require some sort of discharge planning or relapse planning and program that says, here's what happens when somebody gets kicked out. Okay. And we'll get into some of that detail a little later. Property maintenance issues, there have been some complaints that some of the community residents aren't maintained well. There's been, obviously, we've had noise complaints, those kinds of things. So that's sort of the overall, what does the statute allow us to do?
John,
now, yes.
can I interrupt you with
Sure.
a question? The last paragraph here, in which the statute allows us to establish and maintain an operation plan,
Mm-hmm.
how far can we go in dictating what's in that operation plan?
Well, what the statute allows us to do is require the operator to develop a plan. So the city would not be developing individual operations plan. I'll get into some of the specifics as to what we think can go into the operations plan or should go in the operations plan. Once we get it kind of a little bit deeper into this discussion. And once we get into it, I will sort of say probably more than once that as this ordinance is being developed and we get direction from you and we also want, I think, input from the industry itself, from the public and those kinds of things to make sure we have an ordinance that works sort of globally. So there is, developing this does take some time because we have to be sort of careful drafting it and crafting it. But I think that the council needs to kind of be aware that overriding this is going to be a staffing issue. I mean, not only in terms of number of people, but expertise. Cities don't generally have kind of health departments, at least cities in Arizona. That's usually either deferred to the county as far as like restaurant cleanliness or the state through the Department of Health Services. So this is kind of a new area that we're delving into. So that kind of needs to be an overriding, or at least one of the considerations as we go forward, is how do we can draft up the greatest ordinance in the world, but if we don't have the staffing and the expertise to enforce it, it's useless. It's just a piece of paper. So that's something that the council needs to be aware of.
Mr. Mayor, if I could. John, what you're saying about putting into place like an exit strategy or whatever, have the industry come up with it or the House, is much like OSHA does for workplace safety programs and whatnot. They don't tell you exactly what that should be, that you're required to have one.
Yeah, and again, I think that's right, is that, we can set sort of some minimum requirements for a discharge strategy or an exit strategy or a relapse policy. Minimum requirement may be you can't kick them out on the street. And so you figure out, operator, how you're going to avoid doing that. Because again, we don't want to limit the options of the operator for discharging someone if there's a relapse problem. At the same time, I think we can set a minimum standard, and then the operators can figure out ways to meet that standard. So, and a lot of what we're going to talk about, I think today at least, is kind of minimum standards. We're going to set minimum standards, let's say, for house managers. Does that mean that the operator is stuck with those? No, they can certainly exceed those, because it becomes, again, an enforceability type issue. If we have some standards that are so extreme, we have to be careful whether they violate various laws. At the same time, we don't want to try and figure out a one-size-fits-all kind of solution to the problem. I think my experience, especially with the ad hoc committee, is that a lot of the industry folks want to participate. They participated in this program for getting the bill approved, and so they want to be involved in helping make sure that this is done right and it's done workable. It works for us, and it works for the operations, and it works for the neighborhood. So, just to kind of go a little bit more background, the statute that we're talking about isn't a limiting statute. It's sort of an enabling act. It allows a city to do certain things, but it doesn't limit us for doing other things in the same kind of realm. So under state law, we have the authority to deal with nuisances. Our charter tells us that we can adopt local legislation necessary and proper for orderly administration of affairs of the city. And the charter gives the council all the powers granted to cities in the state by the constitutional laws of the state, and all implied powers necessary to carry out the powers granted. So the statute isn't one where the state did what's called preempt the field, saying, that's more of a limiting type statute that says, if you're going to do X, you can only do these things. The best example, I think, recently for us is the election statute. There was a push by the legislature to limit local elections to even-numbered years in the fall. We fought it with a bunch of other charter cities and said, no, our local elections are a local matter. But for general law cities, non-charter cities, they're stuck with that fall even-numbered year election schedule. That's a preemption issue. This is not one of those statutes. So this gives us kind of a broad authority, but I think we can go beyond what the statute has allowed us to do some other things that may not be expressly laid out in the statute. And that comes out of some cases from the Arizona Supreme Court and the U.S. Supreme Court that says that as long as, if there's a statute that grants us power or grants us authority to do something, and it doesn't limit us to those particular things, then we can adopt an ordinance that goes beyond. It can go beyond this statute as long as it's not inconsistent with the statute. So some of the things we'll talk about aren't expressly laid out in this particular bill, but they're, in our view, consistent with the bill. And we'll get into a little bit later. Okay, so as I mentioned before, what's our big limiting factor? We have to be able to provide a reasonable accommodation. So anything we do in terms of this ordinance, what we've done with every other ordinance in terms of the zoning ordinance and those kinds of things, so we always have to have a process for reasonable accommodation. And that's what the Fair Housing Act and ADA always require. There has to be a process for reasonable accommodation. More often than not, that's a sort of administrative staff level process, and it creates small exceptions to the rule. But it's a process, it's not an outcome. So we'll have that included in the ordinance, but it has to be a policy of the city that we provide for reasonable accommodation so we don't run afoul of Fair Housing Act and ADA. Okay, so where do we start? We start with an ordinance that says if you want to operate a group home or community residence, a structured sober living home, you have to apply for essentially a permit from the city to do so. Whether you were in existence 10 years ago or whether you want to come into existence 2 years from now. Once the ordinance is in effect, every single operator would have to come in and fill out an application. So this sort of dovetails with the business license. Business license simply a very basic registry. This is a permit application. What could the permit include? I think we talked about it a little bit more. Name, name, address, phone number of the owner operator. Same for the house manager or house managers. Copy of the group homes or the residence's rules and regulations. Copy of the intake procedures. Copy of a relapse policy and discharge plan. An affirmation by the owner operator that only residents other than the house manager the only residents will be considered handicapped. In other words, the only residents living in a structured sober living home will be those in recovery. You can't have this sort of You have to have people who can only allow people who are handicapped in order to have a community residence. Copies of all the forms that they require people to fill out, blank copies, so we see, and then a processing fee. So that's sort of gives us more information than what's just say a business license is going to require, which is essentially name, address, general description of the type of business. This is going to be a little bit more require. So if it's if an ordinance goes into effect, if it's an existing home at the time, they'll have a deadline within which to file for a permit. In talking with Mark and other staff, this is probably going to tie into the timing of business licenses. I'm not sure we have sort of the capacity or capability we can certainly adopt an ordinance before business licenses go into effect, but similar to the business license implementation period, I think realistically this implementation will occur kind of simultaneous with the implementation of business licenses. That's kind of the practical reality.
So, but this is a standalone to the business license?
It's a separate permit process. So one of the ideas is if a home, for instance, is in existence upon the effective date, they have a certain time frame within which they have to file for the application, and then they have another time frame within which they have to actually comply with the ordinance, 6 months, 9 months, a year, because there may be a need for some changes in the way they operate by doing some of these things. Some may not have relapse policies or discharge plans or good neighbor policies and those kinds of things. So there has to be sort of a reasonable time to allow existing operators to come into compliance. If it's a new operator or somebody who's coming in and wants to begin operations of a particular community residence, all of this would have to be in place at the time they fill the application out or submit the application. Once the application's filed or submitted with all the appropriate documentation and all the requirements are met, the city issues the permit as in legal terms, ministerial matter, administrative matter. It's not a public hearing. It's done at kind of a staff level. If the fee is paid and they meet all the requirements, we issue the permit to operate. There are some bases that we would suggest for denial, or if issued revocation under certain circumstances, and I'll talk about those. Denial revocation. If the owner or operator on the application provides a materially false statement or misleading information, and that's discovered either before the permit's issued, we could deny the permit. If it's discovered after the permit's issued, we can rescind it or revoke the permit. And the requirement would be you can't operate a community residence without a permit. Okay? And just to sort of make real clear, there is a distinction we talked about the zoning code earlier, how we can't retroactively apply the zoning code to existing land uses. That's a function of sort of takings law, constitutional analysis. This is not a land use law, so we can apply it to existing community residences. There's a sort of a legal distinction there between the two. So this doesn't contemplate a sort of grandfathering in. If you're already in existence, you don't need to comply with this. This contemplates that if you're already in existence, you'll still need to comply within a certain time frame. A couple of other...
John,
yes,
can I ask? So then if they, let's say, give false or misleading information, you can also deny?
Right, we can deny.
Even existing facilities?
Correct. Correct. Yes.
Makes sense.
Right.
I just wanted.
And then the question is going to be how do we enforce the denial of that or enforce the revocation of something like that? Generally speaking, it's going to be the same process if somebody fails to get a business license. Mm-hmm. You send them a cease and desist. If they fail to follow through, ultimately you end up in court. getting an injunction against the operator to say this person is violating city law, city code, operating without the proper permit, and therefore, judge, you need to shut them down. So that's kind of how we're looking at the enforcement issue ultimately, if we have to.
Mayor Pro Tem's got a question.
Thank you. Yeah, while we're on this topic, John, they may not falsify drug tests, or they may not sell or furnish the drugs or the alcohol, but they may be complicit in the fact that they know what's going on and they don't do anything to stop it. What do we do about that?
Well, actually, we have some other issues or other bases for revocation in the next couple of slides.
Thank you.
So we can look at, because we can look at, require that the operator provide some background information. These are some bases which we would suggest if an owner operator has, have an employment history of physical assault, sexual harassment, embezzlement, or theft, falsifying a drug test, selling and furnishing illegal drugs, we would not, similar to, in a sense, we wouldn't recommend approval of a liquor license for somebody who sort of violates liquor laws or has a history of violating liquor laws. This would kind of be similar, that we would, and in our case, we have the authority to deny, kind of different than liquor license, but it's kind of the same analyses. If somebody has a history of, say, fraud, that's one of the concerns we have, is that if it's an operator that has committed fraud in the past, insurance fraud, we would not want that operator to operate in the city, because there's the potential, because that is, again, failing to protect the resident if they're taking insurance payments and not providing the service that they're claiming they are. They're doing a disservice to the resident, which ultimately does a disservice to the neighborhood around the group home. If an owner-operator has been convicted or pled no contest within 7 to 10 years of certain criminal offenses, we would recommend denying or revoking a permit. And those could include sex offenses, violent felonies that involve bodily harm, certainly the unlawful sale or furnishing of controlled substances. If the owner-operator or even a staff person like house manager is on parole or formal probation, we would recommend not, including that as a basis for denial or revocation. And if the owner-operator accepts residences other than the house manager who are not handicapped as defined by the Fair Housing Act or ADA. So the purpose, again, of a group home for the handicapped is that the residents are handicapped. So if it's going to be a mixed group of persons who aren't in recovery and persons who are in recovery, again, that goes to the quality of care and the quality of service that the group home is going to provide. And so we want to make sure that these community residences, these structured sober living residences, are the residents in the home are all in recovery.
Councilwoman Orr.
Thank you, Mr. Mayor. So this goes back to what you said earlier, John, as far as it becomes a staffing issue to some degree,
Right.
because you're talking about background checks.
Right.
And then it would then be possible that we put the onus of this on the home. I mean, the management of the home, that they need to make sure.
Right.
They're the ones that need to do the background check of the people that they're employing.
Right, but at the same time, there needs to be,
Some check on our side.
Trust but verify, I think Ronald Reagan
Right,
used to say.
right.
I mean,
Sure.
yeah, whether it's, similar to our health and safety inspections. I mean, if we do health and safety inspections of community residences or businesses, I mean, it may be every year or every 2 years, but you're doing sort of spot checking, and the point of that is that when you do this inspection, if people know that it can happen within a certain time frame, they're going to then maintain the premises or the building, to maintain it up to the code, up to the building code. So it's not going to. I mean, it's unrealistic to expect that we're going to be able to have 100% oversight 24 hours a day.
Right. But we're setting a standard.
Right.
And then we're also saying that you need to be truthful on this permit. And so even the slightest type of, I mean, if they lie saying this person is upstanding and they know that they're not, then that also would be a reason to deny.
Right, because we want to make sure that if what we've kind of learned, and I think what was learned by way of this, when this process is bill adoption, was that the person primarily responsible for the oversight and supervision of the residents is not the owner-operator, it's a house manager or house managers. So that's a key element in supervision, in quality of care and in quality of maintenance and oversight of the residents. So we want to make sure that those house managers meet certain minimum criteria, and we'll get to the training and minimum criteria later, but certainly as a minimum threshold, we don't want somebody who has a conviction for a violent felony or sex offense that's 4 years old. You know, if it's 25 years old, I mean, there's a certain cutoff that we would look at. You know, that you assume sort of recovery or rehabilitation at some point, but there has to be some, you know, year cutoff of recent felonies and those kinds of things. 7 to 10 years is generally the kind of cutoff period we would look at.
I guess I go back to teaching, certifying teachers. And I know the process that our Department of Education in Arizona takes every teacher through, as far as like DUI, that's an automatic. You can't get a teacher's certification. So, but that's a big department down there doing that. So it's quite a job.
You know, so again, you know, we'll have it's kind of contemplated that we can have an annual, roughly, review of the permits to make sure that the operator's still complying with all the permit requirements. Maybe more frequently, in other words, if there are complaints about an operator who has a permit who's not following their own house rules, or there are neighbor complaints about disrupted properties, or if there are complaints or allegations of drug use, illegal drug use, or illegal, you know, or alcohol use going on in the home, that could trigger kind of an on-the-spot investigation.
There you go.
But it doesn't preclude us from doing sort of random checks on a somewhat semi-regular basis to make sure that the home is complying with the ordinance.
Councilman Lozelle?
Thank you, Mayor. John, I just have a question, and the reason I ask this is because I don't want holes found in this later. You know, obviously we want this written correctly. In an earlier discussion, I want to say a year and a half, maybe longer, when we start talking about the recovery homes. Under the Americans for Disabilities Act, which a recovering alcoholic or drug addict is covered under that act. As long as they're recovering, they're disabled, correct?
Correct.
And we never, there's not a definition of what a recovering time is, right?
Correct. It's forever. I mean, that's...
As long as they don't fall off the proverbial wagon.
Right.
Okay. So if a house manager, or whatever we're classifying this person as, is recovering and a house manager, this is not going to be discriminatory toward the house manager.
Well, and I'll get to that in a little bit, but I think what we're going to look for is there's a certain period of time within which a person who's newly in recovery is under sort of a high stress level, just for the simple fact that he or she is in recovery. And to add into that stress level the obligation to manage 6 or 7 other people who are even newer into recovery creates a significant possibility of relapse for that house manager. So right now, you know, we're sort of researching and looking in, and we certainly want the industry's input, is what is a rational or reasonable time frame before someone in recovery should have that additional, or can have that additional obligation of being a house manager, where they've sort of kind of overcome that sort of first hurdle. Is it a year? Is it 9 months? Is it 6 months? Because we do have to be careful about ADA.
Because I do know in the industry that, you know, whether, and this pertains mainly to counselors, but your house managers, a lot of them are recovering or have
Right.
been through a program, so they can relate to it better.
Right.
So I just wanted to bring that up.
Right, and so what we can't do is set an arbitrary time period. Let's say we just say it's a year. Well, if we don't have anything to back that up, any factual basis to back that up, then we probably would run afoul of ADA and EO type things, because those people can still considered as having a disability. But once we get some data and some testimony from sort of the experts in the field to say that first year, your sole focus should be on recovery, and you should have, or that first 9 months or whatever that is, needs to be really on your own recovery and not being responsible for someone else. And then once you get past, let's say, 9 months or a year, then you can start sort of integrating more into normal society, and that's an appropriate time for someone to take on more responsibility, and the data shows that, or the studies show that, then that's kind of the basis on which we need to set that time frame. But I think, and again, you sort of hear the horror stories where somebody is in a house for 6 weeks and all of a sudden he's the house manager. Well, from my understanding is the chances of relapse are usually increased if you give somebody that kind of responsibility when they themselves are 6 weeks in, 6 weeks out of detox. I mean, so I think there's a sweet spot number where we'll figure out. A couple other bases for sort of denying or revoking permit is if the owner-operator is at the time of application not, is a drug or alcohol abuser. In other words, if the owner-operator is in recovery, that's fine. But if the owner-operator is currently using illegal drugs and they're not protected by ADA, they're not considered disabled, or if they're currently an alcoholic, then that would give us pause to say, you're probably not the person who should be operating a recovery home if you yourself have a drug or alcohol abuse problem. One of the issues is going to be whether or not the operation plan is going to require the immediate removal of a resident who relapses. In other words, if a resident relapses, what do we want to happen? Do we want to have them remain in the home? Do we want to require the operator to remove them from the home? And if they remove them from the home, what do we want them to do at that point? Certainly, at a minimum, again, we want to avoid streeting of that resident if they relapse. But the idea is that if a person in recovery who's protected by ADA and Fair Housing Act relapses, legally they're no longer covered by ADA or Fair Housing Act. But secondarily, and probably more important, is it presents a potential bad influence on the other residents of the home who may have, especially if someone's bringing in drugs or alcohol into the home. So what's going to be the requirement? Should that operator be required to remove that person and put them in a different place, a different home, a different treatment center, or what? I mean, those are the kinds of things we need to look at in terms of what's the minimum requirement for a relapse. Another basis for revocation is if there are significant and repeated violations of the house rules or the city ordinance or the house rules themselves. In other words, what we're looking at is if operator, you're going to develop your own rules and regulations for supervision and management of the home. We're going to say, as part of this ordinance, you need to comply with your own rules. And if you fail to comply with your own rules, that then is a violation of this ordinance. And if it's a continuing violation of your own rules, it's a continuing violation of the ordinance, therefore we can revoke your permit. Because at the end of the day, what's going to work in terms of supervision and management of the home is the home's own rules. And the home's own rules are going to have to include certain things we'll get to. So if there's a repeated violation of the operation plan, If there's a repeated violation of sort of, let's say we're requiring a good neighbor policy. If there are repeated noise or disruptive property complaints, if those continue and continue and continue, then one of our enforcement options is to revoke the permit and require that the operator cease operating at that point. Because we can't, and the rationale behind that is we can't legislate everything. Our legislation, our regulation is going to be, you as an operator have to have an operations plan that does these things at a minimum. How you get there is going to be up to you, but these are sort of the benchmarks of what we want to see happen. You choose how you meet those benchmarks. But if you fail to meet those benchmarks, and if you say, here's how we're going to do it, and then you fail as an operator in doing those things, then we can revoke the permit if it's continuing and ongoing. So there is potentially a sort of a hammer here for enforcement purposes.
Councilwoman Orr?
So, John, are we liable as a city?
Are we
liable as a city if there's a home that's gone awry and we have not acted on it?
Well, legally, probably not, because we always have law enforcement and prosecution and code enforcement always have what's called prosecutorial discretion. If you get pulled over and the officer gives you a warning, that's within his or her discretion versus giving you a citation. So, however, if you get pulled over and you're clearly, or not you, if someone gets pulled over and they're clearly intoxicated, and the officer just goes, yeah, I don't want to do the paperwork, just drive home, and that person then drives down the street and kills somebody, we probably have some potential liability there. So it's going to depend on the fact pattern of if we know that there's sort of an immediate threat or threat to public safety, then we need to act on it. If it's sort of more of a management problem, we'll have a little bit more discretion. So it's going to depend on how grave the situation is. Okay, so what are some of the rules and regulations we want to see at a minimum? We want to see that all occupants of the residence, other than the house manager, and it depends on if the house manager is in a recovery too, have to be actively participating in a legitimate recovery program. Whether it's AA, whether it's part of a licensed behavioral health program. In other words, all of the residents of the structured sober living must be in some sort of recovery program. And the operator has to maintain records of some type of meeting attendance or program attendance. We probably can't get the specific records of an individual because there are HIPAA issues and privacy issues, but we can certainly require that the owner at least verify in writing to the city that on a somewhat regular basis that all of my residents are actively participating in X program, AANA, or some other licensed.
What do we mean by a legitimate recovery program?
Well, I think the examples I gave, if it's AA or NA or some sort of licensed behavioral health, where we sort of draw the line as to what's legitimate and what's not. I mean, it's not easy, I'll tell you, but.
Well, I think that could get us into trouble if it's too vague. I've had acupuncturists tell me that they can cure addiction with acupuncture. Would that be considered legitimate?
Well,
or hypnosis? There are a lot of alternative therapies out there that maybe we're not addressing.
I understand, and there are studies that talk about brainwave adjustments that actually help increase recovery chances. So I don't know, but I mean by the way, I'm sort of intentionally being general or broad in this presentation because I kind of want to sort of start at the broad level and kind of then focus down to the specifics later. But I think the goal here is to make sure that the residences are in some type of treatment program that is either recognized in the industry or recognized by legitimate medical journals or something. I mean, and so we'll have to figure that out as what's kind of the cutoff. I mean, if a program is you could stop being an alcoholic by smoking pot, I mean, that may be a problem. I don't know. I mean, I'm not a doctor, but so there has to be some minimum threshold, and again, I think what will be helpful is, in working this ordinance through is getting industry input. What's a legitimate program? What do the medical journals say? What do the industry journals say? I mean, what is a minimum kind of cutoff for a permitted community residence? I'm trying to avoid the word license because then it confuses it with the state licensing.
Mayor Pro Tem's got a question.
Yeah, I did. Thank you. John, we go back to this part where it says, other than house managers must be actively participating. Many of your professional industries today have continued education. And in order to continue participating in those legitimate businesses, you have to continue to upgrade your industry knowledge, not because you took a lesson 2 years ago or 5 years ago, now you're permanently qualified till the day you croak. That's a crock. Be very candid with you, okay? So within the language, I think it's very important in the city of Prescott, people who are taking on the role of overseeing the health and general welfare of disabled people are continually kept up to speed as to what's necessary to provide that service in the city limits of Prescott.
Right. So in this sort of requirement, we're talking about the residents of the home have to be participating in some sort of recovery program. When we say other than the house manager, that simply means that sort of doesn't presume that the house manager is someone who's in recovery. In other words, the house manager doesn't have to be in recovery to be a house manager. So, but we'll talk a little bit later about
I understand that, John, but the house manager, in order to be a house manager in the city of Prescott, needs to have some level of professional credibility in order to function as a house manager in the city of Prescott.
And we will get to that. I have that a couple of slides from here. A couple other sort of minimum threshold rules and regulations. I think this is a key one, is the house manager. Is it a 24-hour resident of the house? Is it a number of people acting as a house manager, worked on a shift basis, 3/12s a week as a house manager? Do you have people working 6-7 days a week in 8-hour shifts? That kind of either individual who's a 24-hour house manager residing in the home, or people who are house managers who come and go sort of on a shift basis, kind of like a nurse or a CNA or something like that would. But at the bottom line is the requirement's going to be you have to have a house manager on a 24-hour basis, 7 days a week. And then again, we'll get to the sort of what are the minimum qualifications for a house manager, because that again is sort of the tip of the sword when it comes to proper supervision and maintenance of the house and the residents in the house. We also want to, go ahead, Mayor.
Go ahead.
Okay. We also want to say that for a structured sober living home, that they don't provide care and supervision, as those terms are defined by DHS regulations, because then that triggers a DHS licensing requirement. So these are unlicensed facilities. If they get into that care and supervision type of business, I guess, then that pushes them into the state licensing scheme, and they're outside of our ordinance.
One question I have is, I guess, for somebody to be providing adequate care, that means that he can't be asleep, so there's probably going to be somebody awake at all times. I guess we don't need to say that. It should be can be assumed in this.
Well, I guess it depends, because the issue of enforcement then comes up is how do you know? Let's say you have a 24-hour house manager who resides in the home, If that person is, if everybody else is asleep and the house manager is asleep, is that, I guess the question is that adequate supervision? But that person's at least there physically in the house, versus are we going to require shifts of people coming and going from the house? Is that realistic? Is that practical? While again, because it's not, the concept of a community residence, it's not like a hospital where their patients in the hospital are there 24 hours a day and the nurses are are providing 24 hours of care, because this isn't really care, this is more supervision. So I'll have to look at that. Whether they have to be awake or simply aware and available if something goes on in the house at night, the challenge is going to be in the enforcement issue of that, unless the industry wants to basically work people in shifts, but that means a lot more staffing for those homes. And again, that's going to be a sort of policy question.
Well, the other question I got too is I've seen a couple homes that they have a fire pit and about 8-10 chairs out there, and supposedly they're doing counseling. So it sounds like, from what I'm hearing from you, there shouldn't be any kind of active treatment going on in those homes. That's probably not appropriate. They should be going to a facility that's licensed to do that.
Right, Mayor. The only limitation is that if there's going to be some sort of counseling or group session, under Fair Housing Act, because this is a resident and these are residents of the home, they would be allowed, the residents themselves would be allowed to sit around the living room or the fire pit and have a discussion, just like any other family would be allowed to sit around. But the minute you bring in, say, a person who doesn't reside at the home, then that would cross the line. So you have to allow, under Fair Housing Act, the residents themselves to gather, just like any other family would gather. But if you start bringing in counselors and other treatment type professionals or people who aren't residents of the home, then you're turning it into essentially a treatment center, which is not consistent with a family use of a residence. So the residents themselves certainly can gather amongst themselves. I think that we have to allow that.
Okay, thank you.
Okay, couple other minimum rules. We talked about this earlier. If it's a lease, then if the operator's leasing the home or the building, then we need to make sure that the lease, we get a copy of the lease and it clearly shows that the home's going to be used for a structured server living home, and there's not a misstatement that it's going to be used for someone's private personal residence, because we've had that problem before. So that protects, especially sort of maybe the out-of-state owners, for instance, who might not be able to tell. And it also protects the neighborhood, because if the property is disruptive and the owner is in, say, California, they may not know what's going on in their home, and all of a sudden they get a disruptive property notice because the home is being used for something that it wasn't intended to be used for, at least by the landlord. Obviously, one of the things we would check on permitting and basic rules regulations is that the property is in compliance with building codes, city codes, and the zoning code. So for instance, somebody comes in for a permit and we discover that that home was established after the adoption of the zoning of the land development code, and it's a community residence in a single family residential, that's not allowed, then we would not issue the permit and then request that the operator cease operations. Or if it's within the spacing, the 800-foot spacing requirement, and they come in for a permit and they're not grandfathered in, we would not issue the permit and request that they cease operations. You're looking like you have a question. Okay.
I think it's going to take a lot of staff to make sure that there's full compliance with all building codes.
Well, again, like I said, on Friday, letters went out to all of the known community residences in town, starting our inspection program. So, it will be And when we talk about all building codes, I mean, we're looking at primarily the health and safety aspects of it, the fire code,
Okay.
the load, the capacity, ingress, egress, functioning smoke detectors, carbon monoxide, those kinds of basic health safety. We're not going to pull out walls to make sure that the wiring was done,
Okay.
But if there's an addition that was done and doesn't have a building permit on file, that's a potential problem. If somebody built an addition to a house and it wasn't properly permitted and they're using that as a fourth bedroom, that's a problem for this permitting process as well as the building code. So it's a way to sort of discover those things as well. The local or the home rules and regulations, I think, need to require that alcohol or non-prescription, prescription or non-prescription controlled substances are not allowed to be used by the resident. In other words, whether in the home or outside the home. If someone's in recovery, in the home, there's no alcohol or controlled substances, prescription controlled substances in the home. And we're going to ask for that as a strict rule, and then we're going to also ask for written policy regarding the use, possession, use, and storage of prescription medications by the resident, because obviously there will be instances where somebody in recovery has a valid prescription for something, as well as non-prescription medications that may be able to be misused, to essentially get high, because there are a lot of non-prescription medications that if you use enough of it, it can be abused. So we're going to try and so we're going to want to know, okay, what is your written policy regarding how you're going to secure these to make sure that drug abuse is not going to occur in the home, even if it's a valid prescription. The limitation on non-licensed residences is they can't dispense the prescription medications. Once you gain control of that prescription medication and it's not yours, and you dispense it, even if you're dispensing it pursuant to the doctor's orders, then you have to have a DHS license. That sort of moves you into that care and supervision kind of realm. So they have to be able to manage it, but they can't dispense it. Otherwise, then they're required to get a state license. And obviously, we're going to want a written policy that says that if you have a prescription, you're allowed to use it properly pursuant to the doctor's orders, but nobody else is allowed to use that prescription medication. Otherwise, that's a violation of the House rules and therefore a violation of our city code. We're also, going to require that the rules and regulations are posted in the house and easily seen and known by the residents, and that a violation of the house rules could be cause for eviction with a certain time frame where you can't be readmitted, 60 days, 90 days, or it depends on how egregious the offense is. A second violation could result in permanent eviction from that particular home. So again, if there is a relapse, if there's a violation of house rules, so globally overarching all of that is you can't just kick them out in the street. You have to have then a policy and a practice of an alternative, either alternative home or some other means of residency for the resident. You can't just put them out in the street. A couple of other rules we would suggest are appropriate is persons required to register as a sex offender under Arizona law and classified as a level 2 or level 3 community risk, which means intermediate to very high risk, would not be permitted to reside at a structured sort of living home. The Fair Housing Act allows us to limit residences without violating Fair Housing Act. Is to say if someone poses a immediate threat to public health and safety, they're not protected by Fair Housing Act. So we can sort of impose these restrictions for the protection of not only the neighborhood around it, but the residents themselves. because this level 2, level 3 is someone who has a fairly high chance of recidivism when it comes to a sex offender. We also were going to require that there's a visitation policy for people to come and visit the residents of the home, that nobody who's under the influence should be allowed in that home. Again, to protect the residents and to try and limit the possibility of relapse. And then last, kind of but not least, is what's your good neighbor policy? It's going to require the residents to be considerate of neighbors, so no excessively loud, profane, obnoxious language, behavior that would interfere with the neighbors' use and enjoyment of their own home. This sort of dovetails a little bit into this disruptive property ordinance, but this is going to be the operator's own rules and regulations that say, hey, you have to, part of your recovery process is integrating back into society. And part of that is thinking outside your own skin and being aware of and considerate of your neighbors. And so we're gonna want to see what the operator's policy is for their residents. And then we're also going to see what's your protocol where if one of your residences, or if your residences disrupt the neighborhood, what does your house manager do? How does he deal with the residents? How does he deal with the neighbors? What's the protocol for sort of solving the problem locally rather than every problem being solved by police and code enforcement? So that's one of the things we're going to want to see to sort of overcome that, I guess, tension that exists sometimes between the group homes and the neighborhood. These are some of the things, again, that fall within, that would push that home into a licensed facility under state law. Detox services. I mentioned this earlier, the mayor. If they're educational or group counseling sessions for persons who amongst themselves in the home, that we need to allow that under Fair Housing Act, as any residents would be able to, or family would be able to get together and do something like that. But we want to limit that just to the residents of the home. So you don't have a home with, say, 6 or 7 residents where you have 15, 20 people in the backyard doing some sort of counseling session. That is a commercial type or a medical or behavioral health type function that should be done in a proper zoning area. And then treatment recovery planning, again, that's a licensed type function. And it should, again, be done in the proper environment, not in the home itself. The home is supposed to be the residence for the residents. It's not supposed to be a medical facility or a behavioral health facility or a detox facility or a treatment center. It's really intended to be the home for these folks who are in recovery. Okay, house manager.
We got one question from Councilman Chiska.
Yeah, John, I remember a couple back that you were talking about the home having to have access, not hand out, but have access to prescription medications or whatever. What happens if it's prescription marijuana?
Well, there is no such thing as prescription marijuana.
Well,
the state law talks about.
They have a marijuana certificate, medical
right.
card, whatever they call it.
Well, the limitation on the structured sober living home is that if someone has a valid prescription, they cannot then take that prescription, possess that prescription, and then distribute that prescription to the resident. They can manage the resident's use of that prescription, monitor it, manage it, but they can't confiscate it and distribute it. Otherwise, it's a licensing function. I don't know the answer off the top of my head to medical marijuana. It's not a prescription medication, technically. I mean, it doesn't fall within the technical definition of prescription. I think it's a certificate or authorization or something like that, but it's not technically a prescription under Arizona law. It's a different term, and off the top of my head, I can't remember what it is. We'll have to look at that. I don't know how we would deal with that. We could, I guess, I don't know. I'd have to look at the medical marijuana statute too.
John, you can also check with the industry.
Yeah.
I mean, like your mainstay folks, like
Yeah.
at Chapter 5 and whatnot. I mean, I imagine they've got a policy already.
Right. And that may be, and again, part of this is obviously this is a briefing of the council. There are going to be, as the mayor said, a number of opportunities for public input, but we want industry input because we, frankly, want industry buy-in. We need to have collaboration to do this in a way that we can do it right, we can do it one time, we can do it comprehensively if that's the way the council wants to go, and do it in a way that actually is effective. It's not for show. So if the industry has input, and industry, everybody's not going to get what they want necessarily in something like this, but as long as there's an ability to communicate and collaborate, and that includes the folks in the industry too. So I think that's a fair response.
Thank you.
House managers, kind of wrapping it up a little bit here. So the statute contemplates a certification program for house managers. So what's the purpose of a certification? And I think Mayor Pro Tem kind of hit it. House managers have to be properly trained and capable of performing their jobs in a safe, knowledgeable manner, including oversight of the house, external, internal to the premises, prevent disruptive client and neighborhood activities, understand basic first aid CPR, effective management of crises, understand medication issues, and understand other interpersonal and behavioral matters. So what we're looking at is some minimum qualifications. And there have been meetings with, and I think the last Mayor's Ad Hoc Committee had a presentation on a possible program for certification, a training program. That would be a 2 or 3 day program for a house manager at a minimum to get that kind of certification through the college here, through Yavapai College. What are some of the minimum qualifications we would probably recommend? High school diploma or GED, a minimum age. Is it 21? Is it 24? Is it 22? Again, that's going to take some, I think, expertise and industry input. Like what's a good age relative to the residents that are there? Certainly don't want someone who's a house manager who's 21 when the average age of the residents may be 28 or 30. I think there's, you're not going to have a whole lot of control over the residents at that point. This we talked about earlier, the sobriety. Upon the date of employment, enough time in sobriety needed to minimize the chance of relapse and recidivism of the house manager. I don't have a date, a year, I don't have a hard number, but that's the goal here. So we can have a realistic kind of threshold, but one that also complies with ADA and EO. And then as far as the training program, one of the things they have to demonstrate is an understanding of the disease model of addiction, because that's what we're talking about, addiction as a disease. So you have to have a fundamental understanding of what it is that these residents are going through, that they are considered disabled, that addiction is considered a disease, and you have to understand that. And then some of the other training issues, first aid, CPR, as I mentioned, disease control prevention, crisis prevention intervention, and then sort of assisting self-administration of medication. And I think we can go, and this is a very sort of minimum outline of some of the requirements that we'd like to see in this certification program. And I think it's called, is it Treehouse? That's the
Learning Tree.
Yeah, Learning Tree, that's it. Molly from Learning Tree gave a presentation at the last ad hoc committee about a possible program and went into way more kind of detail than I'm going to do here, because she has the expertise in creating that kind of training program, collaborating with Yavapai College to develop, like I said, a 2 or 3 day intensive kind of seminar type program where you come out of it and you have your house manager certification for a couple $100. And then you're qualified to be a house manager in a house in Prescott. And maybe statewide, I don't know. I mean, I don't know what other cities are going to do. So,
I'd like to see one up there, conflict resolution on that bottom.
I think that goes into the crisis prevention intervention, but I think that's right. Because that follows on with that neighborhood, good neighbor policy, that if you have a conflict, if your residents have a conflict with the neighbors, your job as a house manager is to, reduce or get rid of that conflict and prevent conflicts in the future. So the house manager's there, like I said, for a couple of reasons. One is obviously to provide the first line supervision to the residents, which, again, the secondary benefit is they're going to be better neighbors to the neighborhood. But also to be kind of the liaison to the neighborhood too. To be out there and to tell the neighbors, hey, if something's going on in the house, let me know. I'm here to not only protect the residents, but to help you as neighbors so we can get along. I mean, that's kind of the bottom line. A couple other things we're looking at is, we've heard a lot of deceptive marketing practices. This is an option, I guess, as far as, is this something we want to include to help protect the vulnerable population, the persons going into recovery, about deceptive marketing practices that are potentially out there. Again, it's strictly primarily there to protect the resident. So this is one of the things we kind of want to look at and want to see whether or not this is something that the council wants us to include later on. The one thing I think is the question of if the operator, well, one of the big issues I guess out there is the potential for insurance fraud. And what happens is that if the operator is not operating properly, if the house operator is not operating properly, and the residents there, and the residents there by way of an insurance policy, a health insurance policy, and the operator's committing some sort of misuse or inappropriate use of health insurance, and the health insurer says we're no longer paying because you're outside, you're committing fraud or something like that, then who suffers is the resident, because the operator says your insurance company's not paying, we're kicking you out. So, whether this is something that we want to get ourselves involved in, we can talk about a little more detail as we go down. And then another one we kind of want to throw out there for you is sort of self-policing. We talked about enforcement issues with staff, but we can't be everywhere 24/7, 100% of the time. So we want to be able to provide in our code as an option the ability to self-police, whether it's an employee or a resident who can come to the city, the proper city staff person, and say, this operator is violating one or more of the house rules, violating one or more of the city parts of the city code, and I want to make a report on this person. What we would do with this part of the city code is to say it would be a violation of the city code for you to fire that employee. Essentially, it's a anti-reprisal kind of rule, or B, if it's a resident, kick that resident out, because we've seen that before or at least it's been alleged before, where a resident raises an issue about improper operations or improper treatment of residences, and the response of the operator is get out. So we want to be able to have that as a potential option, is sort of self-policing by the residents and the employees. We've seen where an employee's actually been fired. Now, state law gives employees a lawsuit or a civil suit for reprisal if they report a violation of law. So this goes a little bit farther and says, you could get civilly cited or criminally cited by the city if you violate this. That doesn't preclude the employee from then filing a separate civil suit later on, but there's nothing to protect the resident who may file a report. So it's something to think about in terms of helping sort of self-police, I guess, the operators.
Councilman Zell.
Thank you, Mayor. John, could we maybe just put it, I don't know, because a lot of times there's public information acts and things that the public has a right to know, but could we put somewhere where it's like an anonymity clause that if somebody reports it, unless it gets subpoenaed, that we don't give up that name?
We can to a certain degree when it comes to city code violations, and this kind of just completes the presentation, so happy to have further discussion. But for an example is if we have a city code violation and somebody reports the city code violation, normally we don't use that person reporting as the primary witness to the violation. What happens is as code enforcement goes out, witnesses the violation for himself or herself, and then the code enforcement officer is the complainant in that particular matter. So we don't have to put the citizen kind of in the middle of the enforcement action. So we certainly can try that. You know, we have that ability to if someone says, you know, I'm a resident of a group home at such and such an address, and the operator's doing this and this and this and this. It's a little bit more challenging because code enforcement is usually external, and if something's going on inside the residence, it's, you know, we may have to even get it like an administrative search warrant. We can try and keep that source confidential, and I think there's ways in the law of doing that. But point is if the operator finds out one way or another, we want to be able to. One of the options is we want to be able to protect that residence from simply getting evicted, because that resident is doing the right thing. They're reporting the violation, whether it's drug use or whether it's, you know, what other violations of the operating the home's own rules and regulations or the city code, or both.
Mayor Pro Tem?
Thank you. It's a two-way street, John. So take that into consideration when you're trying to come up with some language in here, because you can also have disgruntled employees and disgruntled residences that are solely trying to create a nightmare for a legitimate business operator too. So just, you know, at some point you can't have it lopsided.
Understood. And any kind of sort of anti-reprisal, anti-retaliation kind of law, whether it's a regulation, state law, or city code, always requires that, or always says that if it's done in good faith and it's a reasonable allegation, but if it's done for some improper reason, then the person doesn't have the protection. So anytime we would do any kind of retaliation or reprisal kind of protection, it would require that if the person who was making this report, if it was a false report, if it was done for some bad reason, they fall out of that protection. So we would include that.
Well, I would hope so, because, you know, all you got to do is go down to an elementary school sometime and listen to what kids say about the teacher. You know what I mean?
Mm-hmm. Councilman Chiska?
Thanks, Mr. Mayor. John, not that I want to, but are we going to insert ourselves in the situation which has come up in the past where these homes send their residents to the local food kitchens and food banks in order to earn a day or have a daily dose of food? Not that I like I said, not that I want to, but is that come across the desk?
Well, I would say that I mean, obviously we're aware of that situation that exists. And I guess it's the question: do we want to insert ourselves into, if you're going to provide, you know, room, you must provide board. I mean, and again, that gets in that, and that's a. But with the understanding that type of operation has a huge impact on social services. It does in town. So that's part of the problem. So you know, it's ultimately, you know, could we require that part of your operating rules and regulations is that you provide meals? I mean, perhaps we could. I don't know how. Again, it gets to the enforceability issue at that point.
Sure, absolutely agree.
And then the operating model too of the home.
That was the reason I asked that question about how far we can go with operations, because I understand that some of these homes lock the doors at 8 o'clock in the morning, and they let everybody out, and they don't let them back in until 5. So they're out on the street. They have to find their own way to eat. They wander around, if we'd at least require the home to provide meals, that would be a step forward. And if we could require some kind of community service or employment efforts on the part of the home, that would be another step in the right direction, without just letting these people on the street to wander around, do nothing.
Well, as far as, and you and I had that discussion earlier about, can we require residents of structured sober living homes to provide some sort of community service work? Probably not. I mean, you have that indentured servitude constitutional amendment, but can we develop a program collaborating with the industry that says we're going to provide volunteer opportunities that help add to your structure as a sort of separate city program where, they have a volunteer community service type, set up? What the benefit to the home is and to the residents, we can sort of maybe develop. But that's probably the safer route to go versus sort of mandating, because unless the only way to mandate community service is by way of a judicial order, basically a probationary kind of order. So otherwise, I don't think we can sort of mandate it just for someone who's disabled.
Mm-hmm. Okay.
Any other questions, comments from the council?
One last thing, Mayor. I guess to add on to Steve's and Jean's thing, is the meals, I mean, I've always thought this legislation very similar to, the care for the elderly or some dementia or something like that. There are industry standards. You wouldn't just put your mother or father in an institution or a facility that doesn't feed them. And I mean, there's got to be something there.
Yeah, we can look into that and see how that works in industry. I mean, whether or not if you're a resident of the home is part of your payment, does that include just room and board? Do you get an allowance to go grocery shopping? I mean, because again, it's not like there's a cafeteria. I mean, there's a kitchen.
But I know that a family structure. Of course, the family I grew up in, we made food in the house, and everybody pitched in and cleaned the dishes and whatnot.
Well, that'd be a question. I mean, actually, that may be a part of the analysis we could look at as far as Fair Housing Act, is that if the residents are there strictly as for rooming purposes, and it doesn't include eating meals there, is it truly then does it emulate a family, or is it simply a rooming house, or a boarding house? Well, boarding house implies food, but a rooming house where you're simply renting a room. And so the analysis we would do in that is, if all you're doing is renting a room, essentially, and you're not being provided food, does it fall far enough away from emulating a family that you no longer fall under Fair Housing Act protection? And if that's the case, then the argument is, well, it's simply a rooming house, which is a separate zoning category that, we would deal with it in a separate way with our zoning code. So it's a good point. Nicely done.
Councilwoman Orr?
Yes, Mayor, I'd just like to say thank you to John and his staff, because I know you guys put a lot of work in this. I've attended the ad hoc committee meetings, and a lot of the members are out in the audience, members that are on part of the committee. And I think this is a great start when they look back and see where we were a year ago in discussing this issue. So I think it's a really good start. The one question I have about that you talked several times about, we're suggesting rules. You use the word suggesting. So these are standards at which we would hope that the industry, the homes would use, but they are minimum standards.
Right.
And so they could certainly go beyond. I guess my question is, at what point in time would these be hard fast, that if you don't feed your folks, or if you don't make sure that there's no one there doing illegal drugs, so then that becomes a criminal offense, or it's just a violation of regulation?
Well, let me
Consequences,
Let me
I'm
clarify. When I say we're suggesting, that is, as a staff, we're suggesting to you as a council that
Okay.
these are the standards.
And we as a city would set.
Right. That you know, we're not
saying
We're
these
not
are-
telling council, you got to, we're saying, here's a bunch of things that you need to think about, here's a bunch of options, and we're suggesting that these are the standards that should apply. Once you give us direction as to, okay, go forward, give us a comprehensive ordinance, and we work on it, when those are adopted and approved by a majority of the council, those become standards, not suggestions to the...
They become rules
Right,
to the
rules.
industry.
So you either have rules that are set out in your ordinance itself, or you have rules that you require the operator to adopt that are incorporated into the ordinance to say, if you violate the ordinance, you're violating the law. If you violate rules that we require you to adopt, you're violating the law because you're violating the rules, and the rules are incorporated into the ordinance.
Okay. So enforcement becomes
So,
a
right.
big
So when
issue for us.
I use suggestions, it's deference to this body.
Any further comments or questions? Well, I think you've got basic consensus from the committee to go ahead and move forward and add more flesh to this.
Will do.
And possibly we come back another 2 weeks. It'll be too early.
Let me, I'll let you know.
Okay.
Because again, we want to, and timing-wise, I just want to reiterate that the statute doesn't even take effect till August, so we can't really adopt anything till after that. In terms of implementation, I think what we've talked about is we're recommending that to the council, the implementation should occur at the same time that the business license implementation occurs, because they're going to just match up with each other. So I know that you, Mayor, and the council are interested in getting something done sooner rather than later, and we're trying to walk that sort of balance with making sure that we do this carefully and thoroughly and really think it through to make sure that we don't adopt something that ultimately turns out to be a violation of our Housing Act. So we're working on this. Whether we can get it the next step in 2 weeks, or maybe in the first meeting in August, maybe is a better target. But I'll let you know. How about if I just let you know offline?
Yeah, I just wanted to let you know that I think for the next meeting I want to get public input,
Okay.
Particularly from the industry.
All right.
And residents out there, and see whether or not they feel the direction we're moving is going to address their concerns.
Well, and in that event, we can always do sort of a summary of what was done today and get sort of input as we go. I don't want to necessarily, I mean, if you want me to do it again, I'll do this again, but we can certainly get public input at the next meeting, which I think is probably necessary before we really start drafting and crafting an ordinance, is to get public input and industry input to make sure that we're not doing something that is wholly objectionable and it's going to create lawsuits in the future.
Right. Totally understand. Okay, thank you for all that you've done on trying to get this thing prepared today. Second item, please.
Item 1B, request for information regarding July 12, 2016 voting meeting agenda items.
Anybody have any questions, concerns they want to address now before the voting meeting at 3:15 or whatever?
Close enough.
Okay. Meeting adjourned. Thank you. At this point, we're going to go ahead and clear the chamber here, because we're going to go into an executive session for probably about 15, 20 minutes, and then prepare for the 3 o'clock.
Clear the room. Clear the room.
Nothing official yet, but I mean, I think when we go to the ad hoc committee, we see chapter 5, I mean, essentially it's the NARA, the Northern Arizona. Okay, I'm going to go. They really want to be involved, and I think they're the ones who supported the bill in the first place. Right, tomorrow. And